Guys, your clients are the abductors. Go tell them to produce the second petitioner in court. Enough with the lies. You must stop the abductions. You must stop extrajudicial killings. We will not come here to listen to your stories. You have abducted someone. His family is crying, and you are here telling us stories. Enough is enough. Extrajudicial killings and disappearances must end now. We must stop this madness. We must stop these evil things you are doing to us. It is not right to abduct someone and not present them to court. And you are here telling us stories about... Let me speak. I will sit down. This is not right. Why should they abduct someone and instead of producing them to court, they come here to start telling us stories about, I don't know, my client did this. Your client what? Then what are we supposed to do? If the people who are supposed to protect us have turned out to be the greatest threat to our security.
Can we proceed, Council?
Yes, my lord. My lord, we have had...
Four of our affidavits, where we confirm that the second petitioner was under investigation for his involvement. They just concluded demonstration, Your Lordship. Your Lordship, if you look at paragraph 14, it's clearly indicated that as at the time my clients visited the apartment of one Ndiangui, KINYAGIA, the gentleman was not at his apartment. He had left. Their caretaker has also confirmed that the gentleman left in the company of two other unknown ladies, Your Lordship. Their identities was not disclosed. This is at paragraph 14 of my affidavit, Your Lordship.
That is the deponent stating.
Yes.
It's not the caretaker.
Yes, Your Lordship.
Yeah.
The caretaker, I'm aware, Your Lordship, the caretaker is not present.
No, it's not the caretaker stating. It is the deponent.
Yes, Your Lordship, but
So,
part of this information...
So that I record you
Yes.
retain information
Yes.
as it is, rather than attributing it that it is the caretaker speaking. Because the caretaker has no affidavit here.
Yes, Your Lordship, this
So
is the
it is the
statement of
deponent
Samuel
stating
Itegi. Yes.
that information is from the caretaker.
Your Lordship, if part of it Because when my
I've
client
read
visited,
that bit.
yes, because when my client visited, they did not find the petitioner, the second petitioner. So this information, they retrieved it from the caretaker, Your Lordship.
Yes.
That's why it is.
So that is according to the deponent.
Yes, Your
That's
Lordship.
what the caretaker said.
Yes, that's the position.
It's not the caretaker saying.
Yes. So, Your Lordship, this necessitated my clients to break into that particular apartment. And, Your Lordship, an inventory
So who
of
broke in?
my clients that is the second respondent.
Oh, they were present.
Yes, they were present.
The officers.
Yes,
IG was present.
the DCI. Yes, Your Lordship. That is the second respondent.
You said your clients.
Yes, Your Lordship. I am here for the first to the sixth respondent.
So
Yes.
I'm trying to get the names of those who are present. Because you said your clients were present.
Yes.
So who are these?
Your Lordship, Samuel Itegi was present, who the one was on this affidavit, Your Lordship, among others that have not been identified.
Remember,
Yes,
we are in court
yes,
with specific people
yes.
who are named.
To that
Those are the
extent,
people you
Your Lordship,
represent.
can we retain it at the second
You
respondent?
know, I should be recording you and not misrecording you. You understand?
Yes,
So when you say your clients were there, number one is IG. Number two is DCI. So they were present.
yes, Your Lordship,
They were present.
yes. Then as such,
Yes.
And Your Lordship-
Just a minute. IG, DCI. Who else?
the officers, Your Lordship,
DCS.
Your Lordship, so that we are clear, Your Lordship, these are the officers for the first and second respondents who were present, Your Lordship.
I have no problem.
Yes, if we put it as Your Lordship, it's being recorded. The Inspector General of Police in person did not visit, but the officers did visit.
You know,
Yes,
it depends on how you want us to record you. So if you say your clients were present, these are your clients.
yes, and I have narrowed down, Your Lordship, to the second respondent.
So the DCI was present.
Yes, officers of the second respondents. In particular, one is indicated here as Samuel Itegi. The Lordship, when they broke in, an inventory was taken, Your Lordship, and it is annexed to number 1 of my affidavit, and all the items that were collected have also been itemized there. Your Lordship, it is for that reason that we believe the second respondent is still pursuing the second petitioner so that he can answer to some of the concerns that the second respondent raised, Your Lordship. The second petitioner, Your Lordship, I wish to confirm before this honorable court that is not in the custody of either of the respondents. It is now very difficult, Your Lordship, for order number 3 to be complied with. Order number 5, Your Lordship, directing that the second petitioner be produced in the court, Your Lordship, because my clients, Your Lordship, I insist, do not have the
Do
second
not
petition.
insist in court.
Yes,
An advocate. You persuade the court.
Your Lordship, I persuaded this court.
So if you are insisting, they will insist. And
Your Lordship, there are many. I am not
Wait.
expecting a lot from them.
Let me conclude.
Yes, Your Lordship.
If you take that route, they will insist, and the next thing we will have an exchange. So in court, we don't insist, we try to persuade.
Your Lordship, I stand guided and I want to believe, Your Lordship, I have persuaded this honorable court because we are all here to seek justice and for the
So what do you want us to do? As you say you do not have him.
Your Lordship, according to the affidavit that I filed yesterday, the investigations are still ongoing. We are still pursuing the petition. We can be given more time for us to actually investigate.
Are you looking for him or you are pursuing him?
We are
Those are two different things.
Your Lordship, as I indicated, if you look at paragraph 4, a complaint was also made.
Mr. Marwa, the deponent is speaking. Now you are in court presenting.
Yes, my client.
So if you have to use his words, it will make a difference. So what are you asking the court to do for now?
The court should give us more time, Your Lordship.
So are you looking for him or you are pursuing him? You know the difference.
You look, we're looking for the petition, the second petition. Let me put it as that. Yes. Your Lordship, that is all, Your Lordship. I requested that at this point, Your Lordship, my clients be given a bit of time.
Enough with
the counsel for the respondents. I want to begin by referring you to the wording of order number 5. And if you allow me, I'll read it in extenso. That the Inspector General of Police and the Director of Criminal Investigations were named as the first and second respondents, and also the 5th and 6th respondents in their personal capacities, are hereby directed to produce Ndiang'Ui KINYAGIA, the second petitioner, in court tomorrow, the 1st of July 2025. In default, the Inspector General of Police and the Director General of Criminal Investigations do attend court to show cause why Ndiang'Ui KINYAGIA, the second petitioner, should not be produced in court or released. It is clear, my Lord, that in the absence of Ndiang'Ui KINYAGIA being produced in court, the Inspector General of the Police, the first respondent, and the Director of Criminal Investigations, the second respondent, ought to be here before you. Nothing whatsoever has been said about their blatant disobedience of the court order. There has been no compliance, absolutely. In other words, they are not taking the orders of this court seriously. And that does present a very big problem. Secondly, even if we were to believe them, and we don't, that they do not have him, their business is to investigate and know about the welfare of Kenyans. That's why we pay them, that's why they exist. Ndiang'Ui went missing on the 21st of last month. Today is the 1st. So we are talking of 10 days ago. His family did not just complain to the media. They went to Keno police station and reported on the 23rd. And that is in the affidavit of Lawrence Muturi, the first affidavit, the supporting affidavit. So from the 23rd to today, there's nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations and what they have done, if at all, to find Ndiang'Ui KINYAGIA. This matter has been very, very public, to the extent that yesterday, my Lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders. Therefore, we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiang'Ui KINYAGIA in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the inventory of the things taken from Ndiang'Ui KINYAGIA size. This page 10 and 11. If you look at that, my lord, and look at our annexure attached to the affidavit, further affidavit of Florence Muturi, sworn on the 27th day, yesterday, not yesterday, 27th day of June, which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiang'Ui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, floor FM1. Ours is in color. Theirs is in black. Oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my lord.
Just give me a minute.
Okay.
Yes, continue.
Oh, sorry. May I seek your indulgence? My lord, if you look at the date on the one by the respondents, it is indicated 21st with ST on top of 21st.
So that is the one from your side?
From the respondents. I'm beginning to show the differences. Why we conclude, we say it is a possible forgery. If you look, if you compare with the one by the, in support of the petitioner's affidavit, the date 21st has no ST. It's just 21st June 2025. A further difference, 2025 on the petitioner's supporting affidavit is typed while the 25,
I thought you go
yeah.
over the respondents.
Okay, let me do that.
And when you are done, you now come to the
I'll do
petitioner
that.
so that there is.
It's methodical.
Yes.
Okay.
So
The differences, we have noticed
the
several
date
differences.
has 21st.
I had
June
ST
20 yes.
to signify 21st,
Yes.
and the date 2025, 20 is typed,
Yes.
25
Yes.
is written by hand.
Yes.
Then it has 6 items. It ends at number 6.
Yes.
Then it has the name of a witness, Jane Ndiang'Ui. Then when you come to the respondents, not to the respondents, to the applicant.
So
the
you are done.
petitioners.
You are done with the respondents.
I'm done with the respondents.
So the differences are
the
date,
differences are
date,
date
the year.
21st does not have an ST, and the
items
year
are 6. I'm done.
and,
I've marked 21st ST.
yes, and then the 2025 is typed wholly. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started
Yes.
with ours.
So I'm confirming that I got you right.
Yeah, the differences are
21st.
ST and 25 written in pen
Yes.
instead of typing.
Then the items are 6.
Are 6.
The witness Jane
Jane Ndiang'Ui.
Mhm.
Yes.
Okay.
Those are the 3 notable things in that one.
Mhm.
On the one by the petitioner,
Yes.
the date does not have ST, and I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other,
No, let's go.
all of it, yeah.
No, let's go the way you went.
Okay, and then I
you
come back.
identify, then you now
Come
highlight the one you think
Okay.
is outstanding.
Inventory of items above the date taken.
Mhm.
Inventory of items taken.
Mhm.
It says ceased from inventory of items taken.
Stock
Ceased for the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My Lord, this one has 7 items. That is the petitioners. And there is overwriting on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled.
Number 7 is cancelled.
Number 6 is cancelled. Number 7,
Item.
the numbering. The numbering. You can see a cancellation on the letter 6, and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioners have 7 items and the numbering has been changed.
Yes.
Then we go.
What about the witness?
With witness, it is cut, but it appears, the signature appears to be there. This one, yeah. But there is still the layout appears different at the end from this other one. Where is it? And it has the following words after number 7. It has recovered from name House of KINYAGIA Ndiang'Ui. You can see House of KINYAGIA Ndiang'Ui. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7, the difference is actually not the writings, is that on our annexure, the petitioner's annexure, item number 7 is on page 1. There is no page 2 of the inventory. It's whilst
So the petitioner's documents have only one page.
only one page.
Your Lordship, I don't know if it is proper at this moment for me to clarify. So
No. It's one page.
Whereas the respondents is 2 pages. You'll see that number 7 is on page 2. Ours, it's all on one page. You will also notice. Okay.
This is page 2.
Yeah. But you see the one with the copies yeah. So what we are saying,
Just a minute.
you will note from the documents, and I've already stated it, that Ndiang'Ui KINYAGIA has been missing for the last 10 days.
Yes.
I just want to say, my Lord, with respect that it appears, because this is not the first case, that detention without trial is being returned. Kenyans refer to the KANU era when it happened as the dark days. Those dark days, my Lord, at least the state used to acknowledge it's holding somebody by whipping out a detention order. The detention today, extrajudicial detention, is accompanied by a denial. I'm just wondering aloud, why would we have documents that are so dissimilar that are most probably a forgery? We need an explanation from the 2 individuals, Inspector General and the Director of Investigations. And I would like to say that any alleged matter said by the caretaker who has not sworn an affidavit and who appears to have made a general statement, not a statement to the deponent. If you look at paragraph 14 of the respondent's affidavit, it says, the said caretaker informed officers that the second petitioner had left the house earlier in company of another man and 2 unknown ladies. He doesn't say he has been told by her, which he verily believes to be true. It's a marketplace statement. He said to the officers, this is hearsay, should be expunged, unless the lady herself swears affidavit and avails herself for cross-examination. What if the 2 others he left with were an advance party to abduct while the others come back and search? Those are things we can never know.
Yes.
I sit just down with one proposition. The coincidence of the house being broken into by the police, which they now admit, and my colleagues will be dealing with the illegalities of that, and his disappearance, and the conduct of the DCI and the police generally in this country in matters relating to abduction, leads to the inescapable conclusion that indeed they arrested him and then ransacked his house. I yield to my colleagues.
My Lord, very briefly.
Just a minute. Yes, Mr. Otieno.
My Lord, I start from the point that I assume that the respondents recognize that we are in a country operating under the rule of law. And if they accept that fact, then a competent court having made an order, I've never seen orders that are so express and explicit like this one, directing the IG, Mr. Kanja, and the DCI, Mr. Min, to produce Mr. Ndiang'Ui KINYAGIA on the 1st of July 2025 at 11 a.m. That's the first part of that order. It is 12:43 at the time I'm speaking. And the 2 gentlemen have not produced Mr. Ndiang'Ui KINYAGIA. This court specifically directed them that if they fail to produce him, in default, they have to attend court to show cause. So we all agree there is no production, but I can see they are not here. I'm only seeing Mr. Maro. He's not the DCI, he's not the IG. So if we are operating under the rule of law, at the very bare minimum, the 2 gentlemen should be in court, doing the explanations which counsel is purporting to do from the back. Because underlying all this is the liberty and the life of a citizen at stake. We may speak all the English, but there is an individual whose life and liberty is at stake at the end of the day. And that should be the primary concern of all the parties and the law. And in furtherance to that limb, my Lord, Mr. Ndiang'Ui seemed to have only attracted the attention of the respondents.
That is the second petition.
The second petition seemed to have only attracted the attention of the respondents on the 18th of June.
On 18th.
18th of June 2025, and that is, my lord, as per the annexed and the replying affidavit, page 10. Sorry, on the 19th of June. 19th of June, as per the annexure found at page 10 of the replying affidavit, is a letter signed by one Zachary Kariuki, the DCI Operation Support Unit. And that letter, my lord, it is the first time that the question of liberty of the second petitioner is being discussed. Before that day,
Just a minute. You are referring to
page 10 of the replying affidavit of the respondents.
that item is
It's a letter dated 20th of June. It's a letter from National Police Service, the letterhead, Directorate of Criminal
it's
Investigation.
addressed to who?
It's addressed to the Director General Communications Authority of Kenya. The DCI is addressing the Director General Communications Authority of Kenya to help them trace.
The letter is dated.
Dated 20th of June 2025. And on the 21st of June, they are its residents, as confirmed by the inventory, the two inventories. So the only person who publicly is known to be interested in the second petitioner are the respondents, no other person. And it is also not in doubt that he disappears on that 21st of June. If it quacks like a duck, if it walks like a duck, it can only be a duck. And in their replying affidavit, they are speaking to recoveries of items in his house, confirming presence in the scene. They are not speaking to investigating or finding this man, the substance of this habeas application. If they were really minded to protect the fundamental rights of the second petition, and if they didn't know where he is, the report to court today would have been the number of witnesses they've questioned, the track and trace they have deployed, the CCTVs they have seen around the scene, to explain the whereabouts of a Kenyan who they will have said they took in their custody. But to the extent they are not talking about that, they are only talking about the items they've recovered and a purported expose. We can only conclude they haven't. And those are the questions. If the orders of this court issued yesterday were complied with, we will be asking the two gentlemen and their subordinates whose names appear on the inventory to have been present at the residence of the second petition.
Yes.
So, my Lord, as I conclude, I will pray that this honorable court, to the extent that we have this order still in force, to give dignity and to assert the authority of the judicial process, these proceedings should continue with the participation and the presence of the two, Mr. Kanja and Mr. Amin, in person answering this question, and their subordinates who have signed this inventory. Only one agency in this country is known to move around in Subarus, conduct abductions, and those averments in the supporting affidavit of Florence Muturi have not been denied. The presence of Subarus and the gentlemen in those Subarus in civilian in violation of the law has not been controverted. They make no mention to them. We do pray that, my Lord, do give justice to the second petitioner and his family.
Your Lordship, if you want to add.
Yes, Your Lordship. There are certain aspects, Your Lordship. I'll be speaking directly to the affidavit.
Which ones?
Yes, Your Lordship.
Which ones?
Your Lordship, I'll be sticking to the contents of our supplementary affidavit, the issue of the arrest warrants, and averments by manual for the respondents in terms of their interest with the second respondent.
But what has senior counsel done? What has Mr. Wilson?
To the fact of, Your Lordship, there was an averment by counsel for the respondent that they are looking for the second petitioner and not investigating. I wish to point out to this honorable specific paragraphs.
But that's what he said.
Yes, Your Lordship. I'll be alluding to their replying affidavit where they indicate that he is a person of interest, as well as
they have said that.
Your Lordship, the averment was that they are looking for him. Your Lordship, there's a difference between a missing person and a person being investigated for having committed a crime. That was the distinction.
You know, we really have to try and focus on why we are here. You understand the counsel?
Yes, Your Lordship. Yes.
Today was meant to be a very brief day. So, just let me know what you want to add. We have read this affidavit, haven't we?
Yes, Your Lordship.
We have read the inventories, haven't we?
Yes, Your Lordship.
Yes. So just add what you want to add instead of making a day very long. Give us your name.
I'm Mr. Abna Mango, Your Lordship.
Mr.
Abna Mango.
So I can have Mr. Mango.
Yes, Mango is fine. Yes, Your Lordship, I'll be very direct and speak to what has not been. Your Lordship, just referring the court to the affidavit in support of the agency. Your Lordship, there is a miscellaneous.
Let's not go there. We read that affidavit. We are here. We are part of that agency.
It has not been spoken to. It has not been spoken to, Your Lordship. There is the second annexure. The inventory was the first one, but the second annexure, Your Lordship, to the affidavit in support of the agency is a miscellaneous application, number E2362 of 2025. This is the affidavit dated 27th of June 2025.
So which affidavit are you looking at?
There is an affidavit in support of agency
so that we get to appreciate.
Everything is critical. To me, Mr. Maro, there is nothing more critical than when it comes to human life.
I agree, Your Lordship.
So let's not debate. Let's just be here.
Yes, Your Lordship.
When we are going to discuss about habeas corpus, we better understand Article 125C.
Yes, Your Lordship. I appreciate that.
It cannot
But let me
be,
say
it
this,
cannot
Your
be
Lordship.
more clearer than that. So let's not go there.
Yes, Your Lordship.
Just address me what you wanted to say.
Yes, Your Lordship. In the same authority that Babu was just read, Your Lordship, the judge, in that very authority, the first authority, the judge said that it has been established the general burden in a habeas corpus application must be pursuant to Section 1 of remains with the petitioner.
We have not gone there.
Yes, Your Lordship. The court said this is necessary for this court to appreciate.
Which court?
The application was filed is under the custody of the respondent. That is what is missing, Your Lordship, here. It has not been established that indeed the second petitioner is in the custody of the respondent. Your Lordship, my colleague Mr. Mango said that the deponent of this affidavit was not at the scene of the crime. Your Lordship, my colleague has been very selective in reading the affidavit that I filed. If you read paragraph 1, I believe Mr. Mango understands this, that I am a police officer in the meaning of chapter 84 of the laws of Kenya, one of the investigating officer in this matter. He has confirmed that indeed he is the
With your permission, just to say, once the respondents admit that there is contestation of the two documents, they are indeed buttressing our case that we need the DCI and the IG here, and that the court will not be able to completely adjudicate on this matter without that. We are pleading, this being a matter touching on the life, that if it pleases the court, this afternoon would not, it's already afternoon, but late afternoon would not be too soon. We'll be happy to just hang around and wait and deal with this matter to relieve the family of the anxiety. Most obliged.
In matters like this, I don't know how you want us to proceed. Mr. Maro,
Yes, Your Lordship.
you contest their inventory, the copy they have attached.
Yes.
They contest yours. Did you hear them?
Yes, I have them, Your Lordship.
So, the documents attached are contested.
Yes, Your Lordship. But of importance is that they did
No,
not make that document.
let's not go there.
Yes,
Those documents appear to originate from end. You are a client,
correct, Your Lordship.
both of them.
The only one that I believe originates from
Don't
the client is the one that
be
I've
so
attached.
defensive. It's not you.
Yes.
Don't speak as if it is you who made them. Someone made the documents. We are trying to establish the truth.
That is true, Your Lordship.
They are not saying you did. They are saying someone did it. And we clearly can see. We don't require to be a professor to see that
Correct, Your
there is
Lordship.
something there.
Yes.
Who made the inventory?
It is a gentleman by the name Leonard C.J.
CLA.
CLA, yes, Your Lordship.
Do you have that? Do I have that?
Both actually have the name.
You have their copy?
A copy of the inventory.
Yes, the one you contest.
I don't have, Your Lordship, and that is why I still insist.
It's in the petition. And the source is clearly where it was filed in the lower court.
Do you have it?
Not on the documents that I have, Your Lordship.
Were you served with the petition?
I only got the motion, Your Lordship.
You are able to get onto the CTS.
I tried, Your Lordship, this morning, and these are some of the documents that I retrieved. And considering the timelines you gave me to comply, Your Lordship, I confirm even our office has not been served with that particular application. So I had to retrieve the same from the CTS.
Give him the document. Give him our document to have a look at.
Your Lordship,
No,
Sorry.
please, you are
We-
speak through me.
yes, Your Lordship. When we appeared before you yesterday, Your Lordship, we did allude to an affidavit of service, which was not contested. We clearly.
I'm not going to go back to
Very well.
service.
Very well.
No, don't take me there. Do you have a copy of the petition, Mr. Man?
Your Lordship, I have a copy of the motion, not the petition.
I'm asking a specific question.
I
Either
don't
you have,
have-
you don't have,
I don't have.
you don't have.
Yes.
Mr. Mango, do you have a copy of the petition?
Yes, Your Lordship.
Give him. Does he have the attachment? No, no. Does it have?
Yes.
The one you are giving him?
Yes.
Yes. Just give him.
I have it, Your Lordship.
So you have the attachment.
Yes.
So the copy you have,
Yes, Your Lordship.
seems to say, to suggest it originates from your client. Seems to.
Yes, on the face of it, Your Lordship.
That's what I mean. Seems to.
Yes.
Contain the same information.
Yes, but this has 7 items, and the one
Correct.
has 6 items.
Yeah.
Yes.
So they contest the one you gave
Yes.
because of one or two some, and you contest the one they have. Yes. But they are signed by the same officers.
Your Lordship, yes, they're signed by the same.
They appear to.
They appear.
Let's use the word they appear to have been signed.
Your Lordship, I've since discovered that indeed, even the one I have has 7 items, has 2 pages.
There is overwriting.
Yes. Not over. Has 7 items.
There is some overwriting.
On this,
I'm
yes.
just confirming before we leave here so that it doesn't, it's not said that some document was slipped.
That is true, Your Lordship. The second petitioner would have been found, Your Lordship. If you can give us a bit of time.
How much time? I wanted that person, whether he's dead or
Your
alive.
Lordship, as indicated from our affidavit, clearly you've seen the investigations are ongoing.
They have said their story.
Yes,
You have said your story.
yes,
I'm looking at the 2 stories.
yes. Your Lordship, in terms of timing, Your Lordship, we leave it to the discretion of the court. We cannot with certainty say that 3 or 7 days.
We are
will
not
be
interested
sufficient.
in any other thing
Yes,
other than the human being.
I am also interested, Your Lordship. Yes, thank you.
So when can we get this human being?
And Your Lordship, that's something it would be very difficult for me to give.
You know, Mr. Mara, tell your clients,
Yes.
these people, I'm also speaking to these people.
Yes,
There is no way a Kenyan will get out of his abode and vanish from this world without trace. It's not humanly possible.
that's correct, Your Lordship.
So let's stop doing drama and stick to what the Constitution speaks to.
Yes,
We may not like it. We gave it to ourselves. Those are the words. And the future generation. When can we have this person? He may be hiding, I don't know.
there's also
Yes,
that
because
possibility.
your clients are pursuing him.
Yes, Your Lordship.
And he has to live like an animal. So, when can I have this person in court?
Your Lordship, could I be given 7 days to get my clients? And Your Lordship, he can be found even before the lapse of 7 days.
He has been missing since
I believe
21st.
21st.
So today is 10 days.
Yes.
Yeah.
Your Lordship,
All we want
yes.
is this Kenyan.
Your Lordship, the amount
Where
of
is
time,
he? Nothing more. We are not interested in drama. We are not interested in anything. There is a human being missing. So where is he? Is he alive or dead? Just that. The responsibility now is on me. They are asked, looking upon this court, to get this person alive or dead. And we all have a responsibility.
and Your Lordship have confirmed, and I wish to reiterate that.
You know, I've read the pleadings, Mr.
Yes.
Bao. Let's not go there.
Yes.
I've read the pleadings.
Yes.
Yes. We take your story with the forcefulness it deserves. We take their story, we balance the two.
Correct, Your Lordship.
I didn't watch the video these people wanted me to watch, so I don't know what was said in that press conference. But let me make my few remarks here. I've heard you. I have heard the arguments. I've read the pleadings. One thing emerges clearly, that there was an interest on the second petitioner, and officers from the DCI visited his residence, and they were the last people to be in that residence on 21st of June, the date he disappeared. There are inventories which also appear to be coming from the DCI, which are contradictory. The inventories are said to have been signed by a caretaker. The caretaker did not swear an affidavit to say that she was present and she witnessed that the second petitioner was not in the residence. And since the DCI officers were the last people to be in that residence, conducted a search, and this person disappeared, and as contradictory as the inventories are, we need an explanation from the DCI where the second petitioner is. In that regard, I direct the Director of Criminal Investigations do attend court in person on 3rd of July, that's Thursday, at 11 a.m. and explain the whereabouts of the second petitioner or produce him in court. This matter will be mentioned on that day at 11 a.m. for further directions and orders. Thank you. I don't need the ID here. Thank you.
Yes, go 2 minutes, then you proceed.
Ameniambia 2 minutes.
Kawuono wasebiro e doho waluwo kes mar Ndiangui mane rawera mane family of Ndiangui and other spirited lawyers who are in court today, and the main issue was for the body or the person of Ndiangui to be produced in court. There was an order issued by the court for him to be produced, and that has not been complied with. As it is now, it is confirmed that the last contacts that Ndiangui had was with police officers who went with residents without a court order, broke in, purported to gather inventory. The inventories they brought to court were 2 conflicting inventories, which tells you the criminal mind behind all of this. And it is also not disputed that there were several Subarus and men carrying guns who are that residents. And in this country we know which entity moves around in Subarus, which entity moves around in civilians and abducts civilians and keeps them incommunicado for a long period of time. If it works like a duck, if it quacks like a duck, it is a duck. It is DCI and the security agencies that have taken Ndiangui, and now the court has ordered the DCI head, AMIN, to come to court on the 3rd of July for him to explain why he cannot produce Ndiangui to be released to his family. If there is any court case any case they have against him, they are free to file it in these courts, not to hold him incommunicado in violation of his fundamental rights. The Law Society of Kenya is not going to sit back and watch our country being taken away by these stooges of legacy politicians. We are going to fight them. We will not allow it. This is a new country, and it's a country of the rule of law. DCI, AMIN, and his officers must respect the constitution and the law. This idea of moving around in Subarus, in civilian, bearing arms to intimidate, to abduct civilians must stop. This should be the last case where we are witnessing this. In fact, next, we should now be seeking action against these particular officers. And I must say, when the police stop operating in accordance with the law, they are no longer police officers. They are now criminals occupying public office, and we may end up dealing with them as such, as criminals who need to face the full wrath of the law. Thank you. Our newest member of the bar, who has also joined us and must say something.
Thank you very much. I want to say that the DCI and the IG acted in contempt of the court, and it is just in order that they should be jailed for that matter, or rather fined. It is sad if the DCI and the IG can be in contempt of the court, yet they arrest people on a daily basis and they want them to be processed and prosecuted in court. The DCI has decided that there's nothing about prosecution, and they've started persecution. They are persecuting Kenyans, they are abducting Kenyans, they are killing Kenyans. We as leaders, as advocates of Ndiang'Ui, KINYAGIA, we will not stop here. We want to pursue this matter to its logical end. We want this matter to be the last matter of abduction in this country. We want people to learn lessons. This is a nation that we must build together. We will not let Kenya fall as we watch. We are closer to the future than the people who are abducting people in this country. Their time, if they were to die through natural means, then they would die faster than us. So why do they want to leave a rotten country for us? We want a country that will be for the people, by the people, and of the people. And as we speak, we are aware that the DCI abducted KINYAGIA, and we want the DCI to release him unconditionally or present him before a competent court of law. Thank you very much, and I urge Kenyans to continue with the spirit of fighting this government, because it is a defunct government. Santi.
That the Director of Criminal Investigation, the Inspector General of Police, and every other person involved in these abductions, they must stop now. Failure to which we are ready, we are prepared to confront, to face, to fight, and defeat each and everyone who is abducting Kenyans. So, I would like to demand, not to urge, that the cheapening of life in this country must end. It is very dangerous, and if the people in positions of responsibility do not stop the cheapening of life, it will consume them. This is the high time to say enough is enough. Thank you.
1 minute.
And the DCI director were supposed to come to court with two things: either to produce the subject, who is Mr. Ndiang'Ui, or to come in persons and explain the reasons as to why they can't produce him. They have come to court and explained that they don't have him, and they have given their own reasons as to why they don't have him. You know, they have all canvassed in court. I'm sure you all followed that. And so the matter has been taken to Thursday, when the same order is supposed to be effected. Actually direct the DCI director that he comes in person to say where the gentleman is. That, so far so good. We think there's a delay in that back and forth, but we must say that having had our time and our day in court, the family is happy about that progress. We can't fault the court. We can only say that so far the judge has heard and has expressed himself as much. He hasn't made a finding, but he has also expressed those feelings that, look, this is a guy who is missing and he can't have escaped out of this country. He must be somewhere, and that's why he has issued those directions that the DCI comes here and explains all that. We hope as a family that he's well, that he's alive. He knows where he is, he's with them. He is the one who knows where he is, and those who have him know where he is. So us as a family can only hope that he is well and alive, and that's what we are looking forward to.
What are the activities that this missing victim was involved in, and does the family believe that he actually participated in the things that the DCI is accusing him of?
No, I'll not go into what he is accused of, because, you know, once he is brought or he is out, it's a DCI to say what they want with him. At the moment, we don't have anything which we can say that this is what the DCI is alleging against him. I wouldn't even be in a position to speak for him, because what you are now asking me is to speak on his behalf. If there is anything that he did or he did not do, it's for him to come and say in court. It's for the police or the DCI to come and tell the court if they want to charge him. I can't also talk about what he was doing in life. he is still a subject for litigation in this court. In this case, I may say he was doing this only for him to say, no, I was not doing that. So you see where I am in my predicament. So I think the best point to stop at right now is the fact that he is missing. And there is an order of the court for the police and the topmost investigator to come here and tell us where he is. That is, I think that's the farthest we can go in this matter at this particular time and moment. Yes.
Any other question? Maybe just one question, Wakili Wahome. Thank you so much. Yesterday, the DCI director stated that he was a person of interest. I'm using the exact. I don't know why he used that particular tense in terms of using a past tense instead of especially saying that he was a person of interest and he should see them.
Okay.
Does the family believe that he was a person of interest for the law authority?
Well, you're talking about a gentleman who is 30-something years, 31 years. 31 years. He lives away from the other family. And there are reasons as to why they may think they were looking for him. You have heard all that in court. They went to his house, they broke into it, they are arguing he was not there when they were breaking in. And generally they have said they were looking for him. It's for them now to come and tell us why they were looking for him. And we are splitting this into two. First, he is a person who is missing. The first thing as police that you should do is to look for the person who is missing. Okay? You don't suspend one part of your responsibility to pursue another. He is a missing person. Tell us what you have done to look for him. Now, once you have him, now it's upon you now to go to the second phase of it. Now you can prefer whatever charges you have. And when that time comes, you'll now tell us, this is why we were looking for him, this is why he was a person of interest, this is what we are going to do with him, and then we can cross that bridge, isn't it? I think that's the best way. For now, let's not go into what the DCI was saying about him. In any case, they have said it in their affidavit, in the court here, and we are waiting for them to produce him, then tell us. This is the reason as to why we are looking for him in the first instance.
Okay, maybe just last from me.
Sure.
I believe this narration from the DCI by saying that he was last seen by unidentified people, 2 women and 1 gentleman. Are these people not to the family, and does the family take that narrative?
No, they are not people who are not the family. In fact, we have said that clearly. The very people who came and said that he was accompanied by 3 people are the ones who should tell us, have you investigated to find out who these people are? In fact, our position is that they may just be part of you. Okay? You are the one who came up with the information. Tell us, have you tried to find out whom they are? Have you brought any evidence that can say, this is how far we have moved in trying to do that investigation? And that's why we want the DCI, the head of the DCI, to come and tell us, this is what we have done. This is what we have not done, and I'm sure they will do that in the course of time.
Thank you very important.